Okay, page 11. So we're talking about judge-made law still. Judge-made law, court decisions. And that leads us to the third fundamental concept of the United States that begins with the letter S. And I know it's kind of late in the day for Latin. Stare decisis. I know. So Justice Sandra Day O'Connor, she was giving a speech one night. I think it was at Georgetown Law School. I don't remember exactly. But anyway, she said during the speech that stare decisis may be the most important concept of United States law. The most important. I mean, not one of them, but the most important. And how many of you guys have ever heard that term before? Probably, maybe one or two of you, maybe. If it's so important, you think you would have heard that term before, right? Well, you have, but in a different way. You've heard the word precedent, or precedence, right? We say that all the time. Stare decisis is Latin for the idea of following previous court decisions. It literally translates into something like stand on the things that have been decided in the past, or something to that. Decisis is, I can't remember, in Spanish it's decir. To stand on things that have been said. So this is the basic idea in plain English, right? That a court today should follow decisions of previous courts that have gone on in the past that are involving the same thing. They should follow previous decisions. In fact, they have an obligation. A judge today has an obligation to follow previous court decisions in other cases that dealt with the same thing. Why? Why is that important? Why should judges today follow previous decisions? Who cares? Right? Doesn't every case have its own thing? Why is that important? Why can't judges just kind of decide day to day how they want to do stuff? Well, let me ask you this. Is that equal treatment? No. If a judge changes their mind from day to day, you're not treating people equally, so it's not equal treatment of the law. Their problem is you don't have stability in the law if you know the judges aren't going to follow previous decisions. So the doctrine of stare decisis is more than just, okay, what did the court say in the past? It's this whole idea of we have to have stability, equal treatment under the law, all that kind of thing, and that it's important for a judge today to follow those previous decisions, because that way we hopefully know what the outcome will be. Now, with that said, I really want you to know the term stare decisis forms the basis for the doctrine of precedence, that is, following previous court decisions. Now, it's not quite that simple. Part of this whole idea is what level of the court made the decision. So a higher level court, like the U.S. Supreme Court, when it makes a decision, every other court in the United States has to follow that decision because it's the highest court we have. It's kind of like that poker game again. But what if it's a court here in Monmouth, Oregon, at the city level? Does the U.S. Supreme Court have to follow the Monmouth City Court? No. It's a lower level court. So this whole idea of stare decisis has two parts to it, which is pretty logical. Binding and advisory. Binding is when a higher level court makes a decision. All lower level courts in that jurisdiction have to follow it by law under stare decisis. Advisory means that a court has made a decision that's either in a different state or a different jurisdiction or at a lower level or equal level, and so you as the judge don't have to follow it unless you agree with it. And then if you agree with it, then you can follow it. Okay? Now I'm not going to really get into this. If you just know the basic, have to follow, maybe follow. That's all you need for this class. I do want you to know what that term stare decisis means. I don't often have Latin phrases in this class at this level, but this is one I do want you to know because it starts with S, and it's very, very important. Question?
Stare decisis have to know binding and advisory precedents?
Yes, so binding means a judge has to follow it. Higher level court made the decision, so you gotta follow it. Advisory means it's, how do I say it? Optional, only if the judge agrees with it. So let me give you an example, okay? So let's say a court in Iowa, the state of Iowa, applying Iowa law, made a decision that a water bottle is not a weapon because it's too squishy. So now I'm a judge in Oregon, and I have a water bottle case where somebody threw a water bottle at somebody and cut their cheek with the water bottle, right? So now I would say, okay, well, in Iowa, you know, the courts ruled that a water bottle cannot be a weapon. But I don't agree with that because clearly, in this case, the water bottle was thrown on purpose and caused an injury, and therefore, by definition, it was used intentionally and it caused an injury more so than a finger or something. So therefore, I don't agree with that. I'm not going to follow it. So that would be advisory. Now, U.S. Supreme Court, they make a decision, I got to follow it. See the difference?
Yeah.
Yeah. Now, I'm not going to make you, okay, this in law school. At this level of class, all I want you to know, first of all, what does stare decisis mean? You got to follow previous decision. If you know that much, you're good. And I want you to know this idea that the U.S. Supreme Court, when they make a decision, it's binding, all the way down. All the way down. And we'll talk about courts next week, but for tonight, let's just stop at that point with those. All right. So now, let's go to page 14. Okay. So, we're still talking about judge-made law court cases. So now what we're going to talk about is how do you find a court decision? This is legal research, a little bit, just like the very basics. I want you to know enough to where if you see a legal research, a court case cited in like a newspaper article or an academic journal, you know what kind of what it means, all right? So if I want to go find a court case in a library, you guys know what a library is? It's this building that has these things called books. You guys know what a book is? Paper. I'm giving you a hard time. So, yeah, law school, we spent time in the law, it'd be during the law library like constantly. Of course, nowadays it's all on computer, but when I was in law school, I mean, the internet was like, what's that? American Online. Ooh. I can send an email? What's that? You know, literally, it was like just starting to happen back in 1989 and 90. So, long story short, what I want you to know is how do I find a book and how do I cite to a court case? All right. So, first of all, court decisions are going to, when they're written up, this is highly, highly abbreviated, but it gets the point across in this basic format. First, we have the case name. We call this the case caption. Plaintiff versus defendant. I want you to know these terms. That's why I have them highlighted. The plaintiff is the person or company or whatever, whoever filed the lawsuit. We call them the plaintiff. The defendant is the one that's being sued, or if in a criminal case, it's the criminal one that's accused of a crime. So here we have Quigley versus the First Church of Christ Scientists. So Quigley would be the plaintiff, and the First Church of Christ would be the defendant. So on the test, I may give you a case name. Bill versus Ted. Bill would be the plaintiff, and Ted would be the defendant. In this class, it's always going to be that way. The first name is the plaintiff. The second name is the defendant. Now I say in this class, in the real world, you appeal, they may switch roles, the appellant, the respondent. Don't worry about that. You go to law school, worry about that. Okay? In this class, first name plaintiff, second name is the defendant. Now if it's a criminal case, the plaintiff is going to be a government. United States of America, the state of Oregon, the city of Monmouth as the plaintiff. And the reason why is an individual person cannot file a criminal case against another. It has to be a government. Only a government can file criminal charges. All right, and I'll show you what I mean in a minute. Next, where do I go find the case in the library? That leads us to legal citation method. And I guarantee you I will test you on this. I want you to know what these numbers mean. So, legal citation, this is kind of like you do MLA citation for academics and all that kind of stuff. So legal citation, we have a whole bunch of very complex rules that you have to follow, but they all basically, for court cases, follow this formula. We have a number here, we have an abbreviation, and we have another number. So the first number is the volume number, volume. That is the number on the outside of the book, right? The volume. That number is going to be first. The reason it's first is that way you know which book to pull off the shelf, literally. You go to the law library. I go to the California Appellate Court Reporter, 4th edition, and I find volume number 65, and I pull that off the shelf. The second number will be the page. That starts the case. So the middle part here will tell you what court it's in. You don't really need to know that. Volume, name of the court, page number. Volume, name of the court, page number. Volume, pull it off the shelf, turn the page. If you think of it that way, it's really simple. Now, in the real world, it gets a little bit more complex than that, but that's the basics. Now, we have a comma here. 76 Cal Reporter seconds, 792. Same formula. So 76 would be what? Volume, name of the book, 792, page number. Very good. So I'll give you a test question. It'll be something like, okay, this is a real case out of a real court. Turner versus Reed. Turner is the plaintiff. Reed would be the defendant. 22 or App 117 or 177. 22 would be the volume number. Volume right there, see, 22. And then 177 is the page number, and if you look on page 177, that's where the court case begins. So that's volume, name of the book, page number. All right. State of Oregon versus Alan Oliver Cardwell. Plaintiff would be the state of Oregon. So this is a criminal case. Remember I was telling you about that? And then Alan Cardwell is the criminal accused. Now, remember I told you in the real world they go by different names? Well, here's an example. Respondent, appellant. So he appealed this case because he got convicted. But don't worry about that for this class, okay? Plaintiff, defendant. What have you got? You got convicted of a DUI. All right. Yeah.
Is there dates on that?
Oh, okay. In the real world, yeah. So this is 1977, 75.
Oh, okay.
Yeah, I pulled this off my law library book when I came in today.
But not on the. Oh, sorry.
Now, excuse me. So here's what I want you guys to know for the test, right? How to read the case name, plaintiff versus defendant. Simple. Volume, name of the book, page. Simple, okay? Real world, it's a little bit more complex. You go to law school, you take a whole big class about legal research and writing. Then the next thing we have is how the cases are written up over this next section. Fact, issue, holding, or decision. Fact, issue, decision. So this is how court cases are written up. So first thing they're going to do is they're going to write out the facts of the case. What happened? So Bill had a belt buckle and hit Ted in the face with it. Right? Those are the facts. They were both drunk. Issue. Can a belt buckle be a weapon? Issue number 2. Was the belt buckle being used as a weapon in this case? So two issues. Can it be a weapon? Was it used as a weapon? Decision. Based upon the testimony that both parties were intoxicated, the defendant said that he fell off a bar stool, lost his balance, and that's what caused the belt buckle to hit. The evidence has been determined that there's not enough proof to find that it was used intentionally. Clearly, a belt buckle can be a weapon, but in this case, cannot be proven it was used intentionally, therefore not guilty. Fact, issue, decision. And then the court will usually say why they made the decision. Now, I'm making it sound, I mean, this court, the longest court case I ever had to read was like 280 pages. You had to read it overnight for the next day. Sometimes I had one that once that was 400. It's like, you're like going, what are they talking about? So, I'm making it sound so simple. It's not quite that simple. Now, this is pre-computers. Now that we have computers, it's a lot easier, because you can just, Control F and find the term. But back in the day. So for those of you that might go to law school, I just want to show you something. So this is a real court case. So this is the official published version, and what actually, in your book I have this, page 15. So in the real world, on the front page of the book, of the court case, they give you like a little paragraph that's like a synopsis of the court decision, and then they tell you what the major points of law were. This is kind of like Cliff Notes for lawyers, right? I mean, I don't have time to read 200 pages in my law practice, so I go read this overview outline of the case to decide if it's even worth me reading the rest of it. Now, I'm not saying don't read the rest of it if you want to do that. If you go to law school, they'll give you a textbook, and they don't put that part of it in the textbook. And so what you want to do is go down to the law library and pull out the real case, photocopy that part of it, have it in front of you when you're in class, because they might call on you, and say, okay, Mr. So-and-so, what was the Owens case about? Well, let's see. In that case, the defendant was accused of resisting arrest, and when he was arrested, there were more than one officer. And the question was, are you resisting arrest 2 counts or only 1 count when there's more than 1 police officer? Interesting question, right? It's 1 arrest, but there's 2 police officers. So you're resisting 2 police officers, but it's only 1 arrest. So what's the answer? I don't know. Well, it says right here. Court held that it's only 1 count of resisting arrest, even though there's more than 1 officer. Cool, that's good to know, right, for your everyday life.
So that would be considered judgment law or common?
Judgment, same thing.
Okay.
Yeah, so this creates common law, judgment law. By the way, this was G. Maurer, who was the judge in this case. She was a DA that prosecuted Tanya Harding. The Tanya Harding case, Galuli, what was his name? Yeah, I used to work with her. Very, very good lawyer, very good judge. All right, sorry I got sidetracked. It happens about this time of night. So who brought the pizza? No? Uber Eats? Do we have that in Monmouth? We have Momiji, it's good. Page 17. We're still on judge-made law. Now we have to talk about this cool word, jurisprudence. I gotta find my prop. All right, so if you go to this jurisprudence, so first of all, I'm going to break it down. Jurisprudence. The word juris basically means the law, those involved with the law. So a jurist is a judge. A jury is a group of people that decides a case. So juris is the law. Prudence means how you go, behavior, how you do things, right? So jurisprudence, how you go about doing things in the law. Now, the easier way to say it is the study or theory of law. If you go to law school in the United States and you graduate successfully, you will be conferred with a JD degree, not Jack Daniels, right? A Juris Doctorate, a doctorate of jurisprudence. That's what I have. Alex, you have a JD, right? So, a doctorate in the study of law. So now, excuse me, remember we're talking about judge-made law. So this page is talking about the theory of law, kind of a political sciencey kind of thing, all right? Excuse me. All right, so just like in political science or economics or other disciplines, we have different viewpoints on things, right? Different viewpoints, different schools of thought. So like in political science, you have left wing and right wing and up wing and down wing and your wing and my wing and their wing and our wing and all these different viewpoints, right? Economics, same thing. You have capitalism, socialism, and communism, and thisism and thatism, and all that, right? Law, same way. Different viewpoints on law. Now, I don't want to get into all the theory stuff. What I'm talking about real world is how do judges decide cases? I mean, they're human, right? At least most of them. So judges have to decide a case. Now, humans have personal feelings and interactions and biases and ways they think. And so the question is, all right, theoretically speaking, how much latitude does a judge have to deviate from the exact written rule when they make a court decision? Do they have a lot of leeway, a lot of latitude, or just a little bit? Do they have to follow the rule exactly as written? That's what I'm getting at. And should they always follow the rule exactly as written, or should they sometimes deviate from the rule? Will that serve justice by not following the law? That sounds weird, doesn't it? You actually promote the law by not following the law, because that's justice. You're like, what is he talking about? Okay, let me show you. So let's say we had a law. I'm just going to make this up. ORS 811.999. All motor vehicles must have a muffler. ORS, who wrote the law? Legislature, right? State law. Okay. All motor vehicles must have a muffler. So what's a muffler, first of all? That's not really what it's called, but that's what we say in everyday world. An emission control device, right? Like a catalytic converter. Okay. So what's the purpose of a muffler? Why have this law? What's the purpose of this law? To do what? Two big reasons.
Environmental quality.
Yeah, cut down on emissions, right? Environmental. And then what's the other one? Which is environmentally related, but not particulates, but big loud motors, noise, right? So this law is probably written like in 1974. Back when we had, the muscle cars and all that stuff. All right, so fast forward to today. So I'm driving around town in my new car. Isn't that cool? Little Zap car, right? I don't think I even fit in that, but all electric. This is one of the first all-electric vehicles. You can plug it in, charge your batteries up, right? So let's say I'm driving around town, and I get pulled over by the police officer. Hasbrook, how you doing? He's my friend. We used to coach baseball together back in the day. I'm doing pretty good. I've seen you for a while. Kids are grown. He's like, you got a cool car there, man. What happened to the Suburban? Well, gas mileage and all that, so I got a new car. It's all electric. It's cool. He's like, cool. Where's the muffler? Well, it doesn't have a muffler. It's electric. Oh, man, too bad. Sorry. Law says all motor vehicles must have a muffler. Your car doesn't have a muffler. So here's a ticket, $350. Like, what? It's like, hey, just doing my job, right? Right? Okay, cool. So now I'm going to go to court. And I'm going to try and get out of this ticket. And so whether or not I get out of this ticket is dependent upon the judge. And so that's going to be dependent upon jurisprudence. Remember what I told you earlier? By not following the law, you actually are promoting justice. So this is one of those examples. So here we go. In jurisprudence, we kind of have two, they're not exactly opposite, but they're kind of far apart in a way. One idea is what's called legal positivism. And that is the idea that a judge has to follow the law positively as written, no deviation. The legislature wrote the law, the judge interprets and applies it, but doesn't change it. That's legislating, that violates separation of powers. So a judge has to follow the law exactly as it's written, no deviation. Legal positivism. The opposite end is kind of the idea, okay, natural law. Law in and of itself has to be based on the notion of justice, reasonability, and have a reasonable outcome. And if the law is written in such a way that it does not promote justice or has an absurd result, it really isn't even a law. It's just a piece of writing. And therefore, a judge has a lot of leeway under this idea of natural law to deviate from the strict written rule when it promotes the appropriate just outcome. Okay? Plain English. Not flexible, flexible. Right? Okay. So, let's say I go to court and the judge is a positivist judge. They have the viewpoint that they will follow the law exactly as written. Here's the law. Am I going to get out of it or not? Judge is going to follow the law as written. Am I going to win or not? Will the judge find me guilty? Yeah. Do I have a motor vehicle? Yep. Does it have a muffler? Nope. So yeah, technically by the written rule, I'm guilty of that law. I mean, it's an absurd result. The judge will probably say, well, Hasbrook, God, I'm really sorry, but you're guilty. It says all motor vehicles, not some, all. You don't have a muffler, therefore you're guilty. So yeah, you're guilty, but I'm going to fine you 1 penny. Or something like that, right? And the judge would probably say, I don't want to find you guilty, but it's not you're asking me to legislate and to change this law, and that would violate separation of powers. So really what you need to do, Hasbrook, is go to the legislature and have them update this law. Clearly it's not been updated. And so that's kind of the legal positivist. Now that seems kind of lame, doesn't it? The judge finding me guilty, clearly the law. That's the bad side. It's very rigid. What's the good side to legal positivism? Is there a good side? Yeah, there is. Do you want judges just on their own changing the law to match their own personal viewpoint on things? Ooh, that's a slippery slope, right? What if they don't like certain types of people and that kind of thing? You get really... So you want the law to be applied equally. By following it precisely, that promotes equality in treatment. So there's a pro and a con to it, right? Just like most things. All right, opposite end, natural law. If a judge is a natural law thinking judge, now what's my outcome? Think I'm going to win? Am I going to get out of this case? Yeah. So what's the judge going to say? Well, clearly, Hasbrook, this law was never intended to apply to a purely electric vehicle. And it is my interpretation as a judge that the legislature did not intend for this to apply in this type of a circumstance, and therefore I'm going to find you not guilty. Now guess what just happened? That creates what? Cowboy boot case? Precedence, right? So now, if other people get charged with that same type of law, they can say, hey, the Hasbrook case, the court let Hasbrook off because the court ruled that this was not intended to apply to a purely electric car. And therefore, in that same case, under stare decisis, you got to let me off too, right? That's kind of how it works. All right, so for you guys, test. I want you to know the difference between these two. That's the big one. Not a real 40% chance. Yeah, not a high chance this will be fill in the blank. But I want you to know, okay, legal positivists follow the law exactly as written. Natural law, look at the purpose of the law, deviate to promote justice. Real world, let's go to the bottom down here. Real world, right here. Most judges in the real world are a bit of both. It's not one or the other, right? Most judges are going to apply the law as written, unless it leads to a totally crazy outcome like I was talking about, and the judge is going to say, no, that's not right, okay, most of the time. Now these other ones are sort of variations, which I don't really care that you know. Sociological is the idea that law should evolve along with society over time. So like what used to be considered okay, like slavery, no longer. So the law evolves to change. That's also very, very true with technology, internet and stuff, right? So the law changes. I don't want to get too far into the philosophical part, but real world, we as lawyers, this is part of what we have to do when we're going to court, is we have to formulate our legal argument to try to match the judge. We research how judges decide cases, and judges decide cases very differently, so that's part of what we do. All right. So I have covered my area, so that's going to be it for tonight. For those of you that missed last week, if you want, I can just kind of give you a preview. The rest of you guys can learn an overview of what we did last week. Make sure everybody signed in. And that's a wrap.